detective testified that he created the report that I intend to tender into evidence. And I would like the opportunity and the right to try and enter whatever evidence I may have through this witness. If they have an objection, I would just ask that it be taken up at that time.
The evidence is entered. The report was done. The fact is, he didn't read all these things in the report. So, and he's already testified as such to that. With the iPhone, he did a limited search on the 18th, did a report of exactly what he searched on that day, and that's it. For them to go into this witness with things that he never researched, looked at, or anything like that is completely improper. It's the wrong witness, Judge.
Well, I guess it's in the nature of a motion, verbal motion in limine.
Yeah, I'm sorry, Judge, yes.
The judge, it's their evidence that this witness created. He created this report, and during the lunch break, I asked him to take a look at it, see if he could identify it. He opened it up and said, yes, I created this.
Well, I'm going to deny the motion in limine. You're going to have to make your objections. But at a certain point, if it's developing the way that I'm hearing it's anticipated it will be by Mr. Roaring, then we'll revisit this.
Thank you, Your Honor.
So I think we need to sit back, wait, and see what happens, and make your objections. And if you want to approach the bench to renew your motion in limine at some point, you're invited to do so. And then I'll send the jury out and we'll take it up if it develops that way.
Thank you, Your Honor.
Anything else?
Nothing from the state.
Yes, sir, Mr. Cheston. Please bring the jury.
Please be seated.
I hope you all enjoyed the lunch. At least it was good and went and got us barbecue because I asked her for it. So I told her next week we'll have sushi. I knew I'd get responses from everybody. That's a joke. We're not doing that. We're ready to resume the trial of the case. You can cross-examine.
Thank you, Judge. Detective Yeager, when we left off, we were talking, we had just finished about some of the things that you had done in regards to the extraction of the iPhone 5S that you created in January of 2015.
Right.
I'm showing you what's been pre-marked for identification purposes, Defendant's Exhibit 31. During the break, I had you take a look at that, familiarize yourself with that disc, and that is in fact the forensic analysis report that you created based on the extraction of the iPhone 5S that you did in June of 2014. Correct?
It was July of 2014.
So July of 2014.
That's correct.
Same phone.
Same phone, same forensic analysis, yes.
And again, you created this.
Yes.
It's a true and accurate copy of the disc that you created. Or is
It
it
is
the
the
original?
original.
It's the original copy
It is.
that you created.
We create three,
And
one
this,
for the detective, one for the DA, and one for our office.
okay. And this is one of the three that you
It
created.
is.
All right. I'll move to E31.
May I hear him briefly, Judge?
You may.
Thank you. Detective Yeager, you created that report. Is that something automatic you do through the computer or through your technology and your devices?
It's automatically happens as a matter of the procedure that we did.
In that disk, did you go back and search anything or do any search whatsoever of that disk for any material?
not other than what I have itemized in my report.
Okay, and was that a previous disc that you'd actually done a search on?
Yes,
Okay, on that disc, did you do any searches on that one?
no.
So I'll have, Judge, and I would not object to its submission.
Not object.
He said he did, didn't he?
Yeah, well, I don't object to it being admitted for the limited purposes of it being in evidence, I get. I don't have a problem with it being admitted as to he created it. As far as the substance of what's in it, I do have an objection to him going into anything since he has reviewed nothing on that disc.
Well, that question hasn't been asked.
Okay, I'll withdraw my objection to the first question and the tendering of the evidence, Judge.
It's admitted.
Detective Yeager, would you mind stepping down, please? My hands you what's been admitted in evidence is D31. Can you go ahead and please take that out of the sleeve? And you would agree that that has your name on it?
Yes.
Okay. You created it? Okay. You provided it to the DA's office?
I provided the evidence unit for the DA's office.
So this copy was given to the DA's office?
That copy was given to the evidence unit for the DA.
Ultimately, they got it.
Yes,
Is this your handwriting?
it is.
Of Ross iPhone 5S?
Correct.
Open this back up. And this is the same program, UFED reader, that was used to demonstrate your direct examination.
Right.
And so where will I go to open this report? Right here, iPhone 5S report, UFDR,
Yes.
UFED reader?
Mm-hmm.
Do I have to open it through the program? Is that your understanding?
Yes.
Huh? All right. And so the jury understands the report that you went through that was selected, more refined, less comprehensive, is this one here, correct?
This one, that's this one here,
Okay.
that's that. That is a complete document.
This is the complete report?
They're both the same.
How do they be both the same?
Go into the tab that says extraction summary. No, this tab right here on the right. That one.
Okay. This is not the new forensic analysis report that you created in January of 2015.
Right, this is pretty nice.
The second one that you created in January of 2015, it just hasn't loaded yet. Is that what the program is showing here?
Right. This entry right here relates to this entry here. That entry.
This is the one that's loading here.
Correct.
Okay. While we're letting that load, do you remember the differences between this second second forensic analysis report that you created in the first one?
It was the counts of records in the different categories between this one.
Okay. And specifically, what were the differences in record counts?
I don't know what they are offhand.
Okay. Did you go get your reports over the lunch break?
My report has the correct counts of the one I created initially, and then the one I created on the CD on January of 2015.
It does have.
Those are the same counts.
It's the same count.
Right.
I thought you said that the difference was the counts of different categories of information.
That's on a different disc.
Okay. Well, where's that disc?
It's in evidence.
It's already in evidence?
Yes. Let me get my report.
Sure.
It's an evidence control record 232170.
And what is that exactly? 232170.
It's a different extraction than the one I did, the little analysis that I did do, and the one that you're bringing up right now.
Okay. I thought you said that there were two extractions done.
Right. 232170 has the extraction that was not reported in my report, nor was done on January 2015.
Well, which one is the most comprehensive forensic analysis report that shows the most information that was analyzed and acquired from that phone?
The one I created in January was the one I used to do the analysis on back in June of 14. Okay. The other one, I don't know if it's more comprehensive or less comprehensive. It is not the one I used to analyze and that I reported on in my original report that I created in September from my extraction in June of 2014.
Now, let me ask it this way. The first forensic analysis report that you created
Right.
did not recognize messages sent through an application called Whisper, correct?
I don't recall. I didn't look at that.
Do you recall going to meet with a private investigator named Jim Persinger?
Met with the DA's office, yes.
You met with him at the DA's office?
Yes.
Okay. And do you remember that the purpose of that meeting was to determine who was the profile, who was the user
Right.
of certain messages created through the Whisper application,
Right.
correct? There was a limitation with the first report that you created. It did not identify these Whisper messages
Okay.
on that application, correct?
I'll take your word for it. I don't recall.
You don't recall the purpose of that meeting?
No, I don't recall whether or not there were whisper messages on the first report that I created.
Well, we just saw the first report, right, on direct examination.
Right.
Okay?
Okay.
Let's take a look. How many chats are indicated on this extraction report?
42.
Okay. There were way more than 42 messages on Ross Harris's iPhone. Isn't that true?
Yeah, messages are not just chats.
There were way more than 42 chats on Ross Harris's iPhone.
I don't recall.
Don't recall?
No, I didn't look at it. I created this report with this information on it,
Okay.
and then provided that report to the investigating detectives for them to review further.
All right. Well, you would agree that on this report, of the 42 chats, okay, it's broken down into two subcategories,
Right.
iMessage and KIF.
Right.
iMessage is the messaging format that comes with an iPhone.
Right.
KIF is an application that is also a messaging format.
Right.
Okay? Whisper is not on that one.
Okay.
All
I'll
right.
take your word for it.
Well,
I don't see it.
you don't see it. Okay. you went to meet with a private investigator the DA's office hired to determine more information about whisper chats, correct?
I was part of that conversation, yes.
So you knew that this report here that you created
Right.
did not do a full comprehensive search, okay, digest of this phone.
What this software did was a comprehensive search based on the capability of the software at the time that we ran the extract.
Okay? And you met with a private investigator hired by the DA's office in 2014,
Right.
right? Fall of 2014. So just months after Cooper's death, okay? Months after initially extracting information from that iPhone, you knew that the software that you were using was handcuffing you. Okay? You weren't able to digest all the information on that phone.
I didn't know that.
Well, why'd you go to an investigator then? Why'd you go to a
I went to speak with the investigator at the request of the DA's office to meet with him to discuss whisper.
Okay. Did you tell the DA's office that wasn't necessary?
No.
It's fair to say that when you went to meet with a private investigator, you learned more information about that phone than you had previously. Correct?
Probably.
Okay. You learned that the red image, okay, on Whisper, Ross did not create.
I didn't know that at the time.
The private investigator didn't tell you that?
No.
Have you been made aware since?
Objection, hearsay.
Probably do.
He's an expert judge.
Not an exception to hearsay. Become aware or from somebody else that's hearsay.
He's been tendered as an expert on cross-examination. I'm permitted to go into the sources of information he was provided in rendering his opinion and offering his testimony today.
Well, your question didn't really do that.
Well, I'm laying the building blocks for that. That's where I'm going.
Judge, may we approach briefly? I think we can clear this up.
You haven't been, or have you been made aware since that Ross did not create that red
Objection,
image
hearsay
on Whisper?
again. Judge, this is a different issue than I just brought up. It's hearsay if somebody has told him about who did what.
Judge, it's exactly why we approached, and the objection was overruled, and you allowed me to proceed.
That is not why I approached, Judge. This is a separate objection. Hearsay for anybody telling him about what was on the computer later.
Judge, may I respond? It's not offered for the truth of the matter, because it's not the truth. He didn't create the image.
I sustain the objection.
Thank you.
You would agree that there were way more than 42 chats on Ross Harris's iPhone?
I don't know that. All I know is what I did in the extraction.
Are you the head of the high-tech crimes unit?
I'm not.
Were you at the time?
No.
No, who was?
I believe Sergeant Peluso.
Did you work in conjunction with Detective R.B. Smith in analyzing this phone?
Not in conjunction, he did some analysis after I had done mine.
And the witness, come back to the witness.
Yes, absolutely. Just a moment here.
You'd agree that a copy of the forensic analysis report that you created was provided to Detective Escamillo in this case?
The final report was put into evidence, the one from January of 2015. Excuse me 1 second. Yes. And that was the one that was brought up in direct, that was the selected items, contacts and call logs.
The selected items did not contain chat messages between Ross and Leanna Harris.
No, did not.
Were you able to obtain that at some point? A full extraction that contained as many iMessage chats between Ross Harris and Leanna Harris?
Did I?
I'm going to object. I think we're confusing the issues here. He asked about the selected ones. We're not talking about the full extraction. We're talking about the selected with contacts, the person, and call logs. To make sure we're clear, I think Mr. Rodriguez is getting it confused, and he's misstating what the evidence is.
What do you say?
That's not an objection to my question. If he wants to develop his own testimony on redirect, he can. It's not an objection.
Objection is misstating the evidence.
It's not an objection.
Well, whether it is or not, I'm going to overrule it, and you're on cross-examination, and you can redevelop on your redirect.
Yes, ma'am.
Or clarify, or whatever you think. Well, I'm not going to tell you to do that. That's not my place.
Were you made aware, well, you'd agree that this extraction doesn't have a full, complete log of iMessage chats between Ross Harris and Leanna Harris?
That extraction had everything that the extraction was capable of taking off the phone at the time it was run.
Okay, specifically, does it have all of the iMessages between Ross and Leanna?
At the time, that extraction had everything that it was capable of getting off the phone.
You don't know?
No, I just stated.
You don't.
The Celebrate extraction that you have up there got everything that was on the phone that system, that Celebrate software was capable of extracting at the time that it was run.
Okay. Since then, is there more information that's been obtained from that phone beyond this report that you created?
I believe there has been.
Okay.
And that's with the new version of the software from Celebrate.
Okay. So, which detective will know about that extraction?
I don't recall. I don't know because I haven't been in the unit since it happened.
So you're saying there's a new extraction after January 2015?
Yes.
Okay.
It's my understanding there is.
All right. And I mean, you're still working for the Cobb County Police Department?
As a reserve police officer in uniform. I do not work in the high-tech crimes unit anymore.
You don't?
I do not.
Okay. All right. So just to be clear, you don't know which detective or which detectives are fully aware of the contents of that phone?
There are 4 detectives in that unit. I don't know which one specifically did it.
Who are they?
They are, you mentioned Detective Smith,
Okay.
Detective Levon Mason,
Okay.
Detective P.K. Christiansen, and Detective Michael Huza.
Okay. So it's your understanding that one of those 4 that would have had to have done an extraction since you left in
Right.
January 2015, okay, would know the contents of the full extraction, full report of that phone.
And to correct you, that is a full extraction of the phone that the software was capable of at the time that it was run. Subsequent releases have come out because it's been almost 2 years since that was run. And the capability of the new software is to find more messaging.
And the new software has, correct?
is my understanding, yes.
And your testimony is that one of those 4 detectives, or maybe all those detectives, okay, would be aware of all of the information with the new software that's been obtained from that phone.
My answer is that I didn't do it and somebody else had to do it with the new system.
Okay. The Dell Dimension tower computer, there was no hard drive inside that tower, correct? The Google Chromecast, no forensic software is available to extract the data from that device.
Correct.
Okay. I believe your testimony on direct was that at the time there was no forensic software available. Is there any forensic software available now to extract information from that device?
I left that unit in January 2015. At that time, there was not.
Well, as you sit here today, you're an expert in computer forensics. Are you aware of any ability to extract information from a Google Chromecast?
I'm not aware of any. There may be, but I'm not aware. I haven't kept up since I retired. I haven't kept up with the technology as much as I did when I was in it.
Does the Google Chromecast even store information to be extracted?
It could.
Okay. Like what?
Data. All it is a USB drive. It's a USB drive, which for the jury it's just a small, they call them thumb drives, plug it into a USB port. And a Chromecast is a facility to allow broadcast of information between a large screen and a PC. So being that it's a storage device, you could move data to that storage device.
Okay. So if someone has the software today, or since you left, to obtain the data that was on that Chromecast, we'll just have to wait to hear from someone else.
I don't believe it's there, but yeah, you would
Okay.
have to get that from someone else.
All right. Leanna's MacBook Pro. Okay. You identified 13 files of interest, correct?
13 or 7?
Do you have all of your reports in front of you?
I have the one that I created when I created the report for the MacBook Pro on 6/26. And there were 7 files on that one.
No approach.
And then I did another report on 8/4 that included a lot of other data.
Let me stop you. Let me just get right to this.
Okay.
This is your report, correct? That's your name at the top?
Yeah. Yes, it is.
Right. And the incident is assist other unit, crimes against persons,
Right.
correct?
Mhm.
Suspect, Justin Ross Harris.
Right.
The heading is computer forensic analysis. Okay.
Yes.
This is your report,
Yes.
right? And then it's true that on August the 4th, 2014,
I had 13 files of interest off an Apple Pro.
right, and this date, you did a computer forensic analysis and it was completed,
Correct.
all right? And in that computer forensic analysis, pursuant to the search warrant and pursuant to the high-tech crime submissions, you basically looked at all the data on the computer.
Based on what I pulled off there as data of interest, yes.
Okay. But just to be clear, you're looking at everything, all activity of the user.
Now, to clarify, when we do the analysis, we're not looking at every single item. We're looking at items that are of interest or that may be of interest. For example, I won't go in and look at every single picture in a document in detail, or in a folder in detail. I may do just look at the thumbnails for the folder and just preview that to see if there's anything of interest. If not, I'll go on, preview the thumbnails, but I don't look in detail necessarily at every picture. Something jumps out that looks of interest, then I'll blow the picture up, look at it, and look at the details of the data file.
Okay. You would agree with me that in your report, you don't state that there's any sort of limitation on your computer forensic analysis.
Correct.
Okay? You said that it was completed and that's it, correct?
Yeah, it's completed, but that doesn't mean we can't go back later and look for more.
Sure.
Okay?
And during the analysis, what jumped out at you were 13 files of interest,
Right.
okay? A document of Cooper's week chart, correct?
Right.
And these are your words, your notes, as a reminder of what the file is. It's
Right.
age at each week of the calendar,
Correct.
okay? So you'd agree that that document that you found to be of interest is consistent with a parent that is engaged in paying attention to their child's development, correct?
Wasn't my assumption necessarily, it was just of interest.
Why was it of interest?
I made no assumption that it was based on a parent interested in the growth of their child. It was just of interest that it logged the age of each week of the child.
Fair to say it's of interest because it has something to do with Cooper Harris.
Yes,
Leanna's resume.
yes.
Okay. That doesn't really have anything to do with Cooper Harris, though, does it?
Other than she's his mother.
Right.
Right,
Okay.
okay.
And again, you stated she's not a suspect.
As I understand it, she's not.
Okay. A wish list. Okay.
No.
Baby names. And you noted that those baby names are all female.
Correct.
Do you have any idea if Ross and Leanna were trying to have a second child?
I have no idea.
She saved a clip of her sonogram.
Right.
There's a document that you noted. It's called I Just Wanted to Let You Know, but your note was that it's about distress in their marriage.
Correct.
There's a address list for Leanna's baby shower.
Right.
Okay? And that's important for you to know because that provides you with contacts of family members. Right?
People who know the family.
Right.
You would
If
know.
detectives want to follow up and investigate what kind of parents they are,
Right.
this is a starting point.
Right.
A church shower address list. Okay. Also provides names of folks that know this family.
Right.
Okay. It's Time. This is a poem about loss of a loved one. Okay. Do you know any family member that Ross or Leanna had lost other than
No
Cooper
idea.
Harris?
No.
Okay. Do you know when this document was even saved or created?
I don't know from my report. I would have to look at the forensic report to see the dates and times of that document.
Okay. And then a document of See to Believe. And you noted that this was a poem about infidelity.
Correct.
Okay. And that's your interpretation of the poem?
It is,
right?
yes. I mean, all those notes are my interpretation,
Right.
yes.
All right. And then you also noted that there were 3 images of Cooper in a car seat transport. Right?
Correct.
And you noted that it demonstrates the growth of the victim, Cooper Harris.
Right.
You'd agree that there are way more than 3 images of Cooper in a car seat?
Probably so, yes.
Okay. You found 20 images of Cooper in a rear-facing car seat, correct?
Mm-hmm.
You'd agree, and you noted that it appears that the victim was in a rear-facing car seat as late as May 24th of 2014, just a few
Right.
weeks before Cooper died.
And that may very well not been when the picture was taken, but when it was loaded on the computer.
Okay. Your note is that it appears to have outgrown the seat.
Yes.
Okay, but you're not aware of Cooper's measurements or anything like that?
No, it's just an observation, being a father of 5 and a grandfather of 9, and having toted a lot of kids around, that I can tell when a car seat's too small for a kid.
Did you further investigate to see if Cooper was actually well within the range of that car seat?
He was too big for it because his head extended over the top, or was too high on the car seat.
Okay.
Yeah. And again, that was my interpretation.
Okay. You could be wrong.
Could be, but I doubt it.
2 suspect images with a Post-it note on his forehead that states, "Good morning, I love you, me and Cooper miss you."
Correct.
Right? And that was of note to you.
Yes. And I believe that picture was taken at his work.
You also did analysis of a, well, before I move on. On this MacBook specifically, having at least flipped through, scrolled through, and done a complete analysis as your report indicates, you didn't find any evidence whatsoever of searching for in-car deaths.
If I had searched for it and found it, it would have been in my report. If I searched for it and didn't find it, it wouldn't be in the report. If I didn't search for it, it wouldn't be in the report.
I mean, just to be clear though, nothing about murder or homicide.
If I searched for it and found something about it, it would be in my report. If I searched for it and didn't find anything, it wouldn't be in my report. And if I didn't search for it, it wouldn't be in my report.
So either you didn't look for it, or you looked for it and it wasn't there. Okay.
Correct.
And you would agree with me that either you didn't look for murder or homicide, or you looked and it wasn't there.
Correct.
But you would agree with me that in a murder case, you would probably look for anything that indicates a file about murder. Right? And there'd be no reason why you wouldn't look for that.
Objection, Judge, if you could let the witness answer before he starts the second question.
You'd agree there's no reason why you wouldn't look for a file that has anything to do with murder.
Correct.
In this case, given the circumstances of Cooper's death, there's no reason you wouldn't look for any file related to child deaths inside vehicles, right?
If I searched for it and found it, it would be in my report. If I searched for it and didn't find it, it wouldn't be in my report. If I didn't search for it, it wouldn't be in the report.
Do you know which one?
Which one what?
Which one is it? That you
I
didn't
don't
look
know.
for it, or you looked for it and didn't find it?
I can't tell you.
But you were specifically told, though, that Ross and Leanna had allegedly told the police that they had researched in-car deaths,
Right.
right? So having been told that they had allegedly done this researching over the internet, you would absolutely look for that very thing, right?
More than likely, yes.
Right? I mean, you've got a ton of experience. You've done way more devices in a case than this one. As you said on direct, you're well equipped to do it, right? There's no reason why you wouldn't be looking for this stuff. And you did look for this stuff.
I
And you
very well
didn't
could have
find
and
it.
didn't find anything.
You
Correct.
didn't find it. The reality is that having been told, having been given a request form, having been given a search warrant that specifically alleged that Ross and Leanna told them that they researched in-car deaths, you didn't find anything in this Apple MacBook or that iPhone that would corroborate that allegation.
Objection, asked and answered.
I'll allow it.
Can you answer the question, please?
You say it again?
Sure. Having been specifically told that Ross and Leanna had allegedly stated to detectives that they had researched in-car deaths on the internet, you found no evidence on the iPhone or Leanna's MacBook to corroborate that allegation.
I found nothing that made statements to that effect. Correct.
On direct, you talked about a My Passport external hard drive.
Yes.
It's on the same page of your report that we were just talking about. You didn't go over any of that on direct, but I'm going to ask you. You found 15 files of interest on that external hard drive, correct?
Yes, that's correct.
One is an Excel spreadsheet of contacts for a police department, correct?
Yes,
Okay. One's a document about a 50-round basic police handgun course,
correct.
80-hour curriculum of Alabama lateral entry police officer training.
Correct.
Hotel rates for police officers, right?
Correct.
Alabama child restraint law in 2006.
Yes.
More law enforcement hotel rates. Fair to say all of these documents, or most of these documents on this external hard drive are law enforcement related, and specifically Alabama law enforcement.
Yeah, most of them are, yes.
Okay. Did you investigate the context in which, or did you investigate to find out the truth about why these are important?
I don't do that investigation. My investigation is finding this information, to pass that on to the investigating detectives who are investigating the crime.
You want to provide detectives with a starting point, I guess?
Well, a starting point or anything that may be pertinent to assist their investigation.
Okay. And it's fair to say that having been specifically informed by detectives in the exam submission form and in the search warrant that Ross had allegedly researched criminal statutes pertaining to this case on the internet, that's why this was notable to you, right?
Yes, because it showed a contact or a desire to be associated with law enforcement.
Well, did you know that his brother is a sergeant with Tuscaloosa Police Department?
I had no idea.
No idea.
Nope.
Okay. Did you know that Ross was paid to do work for the Law Enforcement Academy of Tuscaloosa? That he rebuilt
Nope.
their website?
No.
No idea.
No.
The Sandisk Cruiser. That was State's Exhibit 299. 299.
Okay.
Okay. You found nothing.
Correct.
Okay. They admitted into evidence the contents of an electronic device where you found nothing.
Correct.
Okay. And by nothing, it's nothing that is consistent or corroborates the allegations that were detailed in the search warrant or in the evidence submission form
Nothing of evidentiary value
for the state.
for the state. Yes.
And that's what you're looking for.
Correct.
Items of evidentiary value to the state.
Correct.
On the PNY SD card, that was State's Exhibit 298. 298. You found nothing.
Correct.
Nothing of evidentiary value to the state,
Correct.
because that's what you're looking for. Correct?
Correct.
You talked about 2 different Lenovo ThinkPads. The first that I want to talk to you about is a Lenovo T510 ThinkPad.
The 510.
That's right. Can you
That's
get,
one we got at a later date.
that's right. That's the older one, correct?
Well, it's older just by the model number.
Okay.
Yeah.
That was actually Ross's old computer. Correct?
As far as I know, it was the property of Home Depot because it was encrypted, and we had to get the encryption from Home Depot in order to in order to acquire it.
Okay. And this encryption, I mean, that's something that Home Depot did, right? Because
Yes.
it was in their storage, right?
Correct.
They're protecting their property, right? That wasn't anything that Ross did to try and
Right.
hide evidence.
That was something Home Depot does. And that's to protect the corporation.
Sure. And on June the 20th of 2014, this this Lenovo laptop, is this the one that was in sleep mode on June the 20th?
Are you referring to the T530?
Looking at your report page, those aren't numbered. Let me see the report,
Yes.
please. Okay. 275.
Okay, 275. Okay. Okay.
At the very bottom of the page. What Lenovo ThinkPad laptop were you analyzing then?
That was the T530.
The 530?
Yes.
Okay, well, we'll get to that in a second. The T510, okay. There was literally nothing stored on that device, correct?
No, there's no data evidentiary value on that device.
Okay. And Detective Stoddard requested an analysis of that computer. Isn't that correct?
One second, excuse me. Yes, he did.
You remember when he did that?
On August 19th.
Once you got the encryption code, you were able to power on that computer?
That's correct.
Okay. And you'd agree that the times for the suspect machine was off by a little bit by
2 minutes.
2 minutes. Okay. That's not unusual for an electronic device to not be 100% synced up with time.gov, which is what you used as kind of the control for time. You'd agree that's not unusual?
No, it's not.
Okay. Is every device different as far as tracking time, the accuracy of time?
Well, they used to say the watch is as accurate as a computer, and computers are notoriously inaccurate in keeping time. Okay. So, yes, generally you'll find the times on the computers are not the same as the government time or the absolute time.
Okay. And with electronic devices, I want to kind of broaden it. I mean, we're talking about computers, phones. What about surveillance videos?
I have no idea about surveillance. Well, they can be off because usually that's set by the user. But if we go back to a second for phones, phones are different.
Okay.
Okay.
Why are they different?
Because they're on a cellular network, and that cellular network is what keeps the time up. So they're constantly being updated to ensure that the time is accurate.
So that's a good measure of time. I mean, that's a pretty accurate measure.
Yeah, it's not time.gov, but it is a good accurate measure of time, yes.
Do you know what the kind of margin of error would be?
No, I haven't looked at
Fair enough. On that note, looking to the Lenovo T530 ThinkPad. Okay. Over the break, I had asked you to take a look at this disk. What's been pre-marked for identification purposes is D32. And you recognize that, correct?
Yes.
That is
Or the Lenovo T530.
Right.
Steve.
That was the laptop computer that was in Ross's possession when he was arrested.
Right, and also property of Home Depot.
And is this fair and accurate copy of the IEF report that you created?
That is the original.
That's the original. Okay. I'll move D32.
No objection.
Admitted.
Detective Yeager, will you step down, please?
Sure.
Assist me in the demonstration of the contents of this IEF report. On direct, there was a disk of selected data from this computer, all right? And it only had 5 links, all right? You'd agree that this IEF report is a full computer forensic analysis of the contents of that computer, okay? The format's the same, right? The only difference is there's more information, okay? Now, if you would, switch places. I'm gonna let you take over the computer. Do you teach law enforcement in computer forensics?
No, I don't.
Did you ever?
No.
Now, if we wanted to know what search words Ross Harris typed on this computer, how would we do that?
There's, this item right here. This item right here. Okay, those are search queries would come out under our search query.
Click on that, please. You said that search bar up in the top right-hand corner, that's where you can identify very quickly. You can type in a word to see if Ross Harris had ever searched for that word. Okay? Will you type in child free? You agree with me? No results for child free.
As a search term, yes.
Okay. And what if we put a space between child and free?
Go ahead.
What's the difference there?
There is no returns on that,
Okay.
search term.
Okay. So it doesn't matter whether he searched it as 1 word or 2 words. On this computer, he never searched it, correct?
He never searched it.
Okay.
Now, there's a difference between searching and just entering the URL address.
Okay. And that difference is going to the URL search box at the top of Internet Explorer, Safari, or one of these web browsers, and typing in specifically reddit.com/r/childfree. Okay. What y'all talked about on direct, though, is this same computer. Okay. You specifically created a report about child free, right?
Right.
And in that report, you did not include the fact that he never searched in the parse search queries. He never typed in the words in a search bar, Google, Bing, Yahoo, child free.
Not in the search term, correct.
You didn't include that in that report.
I didn't include that it wasn't there.
Right.
Why would I include that if it's not there?
Well, you didn't include it, okay, because it does not provide the state with any evidence of researching child porn.
Objection, that's argumentative,
It
Judge.
is, I sustain the objection.
You didn't include a parsed search queries category in that report.
Correct.
Right? So with that report that you talked about on direct, detectives wouldn't be able to take that report and see, did Ross type this word? They wouldn't be able to do that there. Right?
On the report with 5 entries of child free in it?
Correct.
Not as a search query, no.
Right. But on this one, you can. Right? On this report.
Well, there's no need to because there are only 5 entries
Right.
in the report I created.
Right? And in the report you created, it was clicks from April of 2014, correct?
One of them was an actually typed address,
Right?
and 4 of them were clicks.
Okay. Did you investigate the context or the truth surrounding that web visit?
No,
You did? Do you know if anyone did?
I don't.
Just circle around so you get a better view of the monitor. You're aware that Ross Harris used Reddit all the time, correct?
No.
You're not aware of that?
I know I found some Reddit entries, I'm not aware that he used it all the time.
Okay. If we typed in the word Reddit.
Now, you're in part search queries. These are gonna be queries that actually went, see where it says search engine?
Right?
That means you were in Google or Bing or some other search engine and typed a query.
I understand, and we're gonna go through it.
Okay.
But right now, we're on parse search queries. You would agree that he typed in Reddit as a search query
Right, you get a lot.
a lot, okay? And as far as times go, you can scroll over to the right, okay? And there's a column here that allows you to view if there is time information about that result, right? Why aren't there any time information results for each one of these files?
I don't know, scroll over to the left, please. I can't tell you why there's not time entries there.
Okay.
I'd have to go back and talk to the vendor.
Okay. It's not uncommon for some files to have information about the times that they were visited and some files to not. Correct?
Generally, not as a rule, but generally, there won't be times because there are entries that have either expired or been deleted, and all the information may not be there.
Okay. There's no indication here that the time information was deleted,
No, I'm saying that the whole record may have been deleted.
just by the computer itself. The computer has its own processes, and it might not store some information, and it might store others.
No, if it was an active record, it would have a time in it. What I'm saying is that this entry of this browser activity may have been deleted, and as a result, the time wasn't still in that record.
Okay. Now, if we wanted to look at everything that Ross searched on a given day, we can do that with this, right?
Right.
So for example, 06/18/2014.
It's just taking time to search it.
All right. All right. This allows the person reviewing your analysis to know what he searched, what terms he typed on June the 18th. Okay? Did you investigate or follow up on the context in which he searched pedal train, pedal mondo?
Again, my analysis is to get the information, to extract all of this, provide this vehicle or this output to the investigating detectives so that they can go in and find the things that were of interest in their investigation.
Okay. Now, I'm not talking about
hitting the streets and interviewing witnesses? Did you follow up and investigate within this very own device the context in which a pedal train, pedal mondo search was done at 3:23:20 p.m. And actually it's UTC.
So it's it'd be 4 hours earlier than that.
Okay, so we subtract 4 hours from these times.
Right.
Okay?
Because UTC, just for the jury, UTC is Greenwich Mean Time. It's what pilots use. They also call it Zulu time. And that's the median, that divides days. So that's the 0 hour. And before it is midnight, after it's 12:01. So UTC time is recorded by all computers because it's a common time. So daylight savings time in the eastern time zone is minus 4 hours from UTC time.
So in June of 2014 in Georgia,
It's minus 4.
it's -4.
Right.
Okay. Now, again, not talking about you going to interview witnesses, interview friends. Did you investigate the context of this search on any of the electronic devices that you were asked to analyze?
No.
In April of 2014, you noted in your very specific report that there was this entry about child free.
In April?
Not that you did the analysis in April, but that subreddit was visited in April. Did you know that?
I don't know what you're referring to.
Your report.
Which I have right in front of me.
You created a specific report about the child-free subreddit.
Right.
Okay? When did Ross visit that website?
I don't have that on my report. It's on the forensic report, and then we have to look at that.
Showing you a printout. I know it's small. Those are the 5 links that were in your report that were discussed on direct examination, correct?
Correct.
All right, and there are times of last visited date and time,
Right.
okay? And all 5 were April the 28th, 2014,
Correct.
at approximately 2 o'clock
In the afternoon.
in the afternoon,
Correct.
okay? Never again did he visit these sites.
Never again was there another one in this computer as of June 19th of 2014 that you visit site.
All the evidence you have is that this child free was visited once in April.
4 times in April.
Okay.
5 times in April.
Okay. Did you look at those websites?
I did not.
Well, how did you know that child free was even relevant to this investigation if you didn't even look at the website?
More than likely, it was a search for child or child free, and that's what came up. And I turned that over to the investigating detectives for their follow-up.
So you had no idea if this was a website about getting free stuff for kids.
Correct.
Did you ever do a follow-up into this website? Or who did? Who would I ask questions about regarding investigating child free?
I would imagine Detective Stoddard, who was the lead detective on it.
That's it?
He's the only person that knows about child free.
Objection calls for speculation, Judge, and relevance as to who knows about it.
Well, I sustain the objection.
Who did you provide the child free report to?
Detective Escamilla.
Okay. So Detective Escamilla should know something about that, correct?
He'll know about my report. I can't say what he did with it after that.
He may or may not have investigated it. Okay. It may or may not actually be important. Correct?
Important to what?
This case.
It may or may not be,
Right.
but an investigation would determine.
And so if we want, and back to this full report of Ross's activity on the Lenovo work computer, you can look at what he searched on June the 17th.
Right.
Okay? Every single day leading up to Cooper's death. If you want to know what Ross was researching on this computer, this will tell you, right? What he's typing, correct? If I type in the word how, right, this will give me any time the word how was typed in a search toolbar.
No, it'll be, anytime the word how is in that record.
Okay. You'd agree that this search term here, how many people join the master's lottery? Okay. If we type in how to, this analysis allows whoever's examining this computer to know that Ross typed in those search terms on June the 9th, 2014. Okay. What search terms did you type in to this parse search queries toolbar to find out any items of interest?
I don't know if I did type any in. I got no hits because it's not in my report.
In your report, you didn't list out all of the terms that you used.
Correct. I only listed out the terms that gave me a return.
Do you know how many searches you ran for this computer?
I don't.
Okay. Do you know how long you spent on this computer?
I don't recall, but just based on the fact that it was about a month before I created the final report,
Okay.
probably significant.
So did you spend a lot of time on this computer? Analyzing this computer?
What's a lot of time?
A month?
No,
Okay. 3 weeks?
no.
Okay.
I probably spent hours, maybe a couple days.
All right. Maybe a total of 48 hours?
Maybe. That's probably a bit much, but
All right. So maybe 36? I mean, what's...
I don't know what the
exact-
number is. I don't have a number to tell you because I don't know what that number is, okay? I spent time searching through the computer, looking for things on the computer. What my report reflects is those that were positive responses to searches.
Do you believe you were thorough?
As thorough as I could have been at the time, yes.
Okay. Is there anything going on at this time that would have prevented you from being thorough?
Just a lot of activity.
Okay. But I mean, you've been doing this a long time, and you've got a very sophisticated unit. You were well equipped to handle all these devices, right?
We were equipped to handle it.
Okay. And do a good job?
Oh, absolutely.
Okay. And so when you were being thorough
Okay.
and spending hours and hours examining this device, okay, you didn't find any research of how to survive in prison, correct?
I did not. As I said, if I did, it'd be in my report.
Okay.
If I didn't, I either didn't search for it, or I did search for it and didn't find it.
Can we go back to this one? Are you still there?
And I'm gonna go through different portions of the report here.
Oh, just be mindful of that.
Sure, of course. You were aware, however, that Ross had been alleged to have researched how to survive in prison on this very computer.
Okay,
Correct?
I believe so from the request that we got.
You never wrote a report to say the allegation that he researched how to survive in prison does not exist.
No,
You never wrote that.
I don't write reports about things that don't exist.
Even if
Even
the
if
police
it's an
allege that
allegation.
they do.
That's up for the investigating detective to find out.
Did you tell anybody Ross never researched how to survive in prison?
No, because if I did and I found it, it would be in my report. If I didn't find it, it doesn't go any further than that. I don't report what I don't find.
Well, you included in your report several times, no items of evidentiary value or no items of notable interest, right?
For the entire device.
For the entire device. Okay. So when you agree that when you find nothing, you can say, I found nothing, right? You did.
But when I found something, I reported it.
And the only thing you found on this device was child-free,
That's correct.
right?
Right.
In your opinion, the only thing of evidentiary value to the state on this device is child-free.
Correct.
You take the stand, please. Just a second, Judge, please.
Sure.
Detective Yeager,
Yes.
you had mentioned on direct about the importance of working off of a copy, an exact copy of the data that you extract from an electronic device.
Right.
Okay? I believe your words were, you don't want to change the original evidence, right? That's important to maintain the evidentiary value, the integrity of a piece of evidence, right? And in your line of work, or at the time, electronic devices, phones and computers, okay? If someone were to power on the original Lenovo work computer, okay, and type in child-free, okay, and then there was an extraction done, okay, that report, right, would indicate something very different, okay, a web visit later in time than the original when it was taken into custody, correct?
Correct.
You don't want to tinker with the original piece of evidence.
Right.
Right? Do you know if anyone powered on and manipulated and scrolled through any of the original pieces of evidence in this case?
I know that I had one computer that was in sleep mode,
Okay.
and when I opened it up, it began to boot up.
Mm-hmm.
I immediately shut it down, powered it down, and made note of that in my report.
Okay. You did not want to change the original piece of evidence.
Correct.
Okay. Are you aware of anyone else, any detectives in this case, anyone else that powered on and manipulated the original pieces of electronic evidence in this case?
I am not.
That would violate standard operating procedure for the high-tech crime squad, wouldn't it?
Correct.
you had mentioned the San Bernardino case and Celebrite's ability to basically get into that phone without Apple's assistance.
I didn't state it as fact. I said I believe that they were the company.
That's your understanding.
Yes,
You said that Celebrite's the gold standard,
it is.
right? You're aware that those folks in the San Bernardino case, they had burned items of evidence, correct? They had tried to.
I'm not aware of what the status of that evidence was.
Okay. Ross's iPhone was not encrypted, correct?
As far as I know, yeah, it
Okay.
wasn't.
There wasn't any indication whatsoever that he was deleting applications or hiding evidence on June the 18th.
I don't know.
It wasn't.
I don't know that.
Yeah, it wasn't necessary for you to get the assistance of the FBI or Celebrite to hack into his devices because he had somehow manipulated them, right?
No, that's correct.
Would it be fair to say that some devices you did a comprehensive, spending hours of analysis examining those devices, and some you just pulled the information and just gave it to someone else to do?
I did, and that was based on the request of the investigating detectives.
That's all I have right now, Judge.
Redirect.
Yes, Judge. Mr. Rodriguez said that this form said that the police stated that they, the defendant actually researched, or said he'd researched penalties or something about prison, correct?
Correct.
Okay. Now, what does this say?
Says, the male suspect also made statements regarding details about criminal charges, making us suspect that he may have researched the penalties for a case such as this or specific criminal charges such as murder.
Okay, so they didn't put in this that he researched anything about prison, or he said that he researched statutes. He said that he made statements about details of criminal charges, correct?
Correct.
And have you watched his interview or anything? Did you get that deep in this case?
I'm sorry, I didn't know.
Okay, and again, just to make sure we're clear here, your role in this case, was it majority to just extract the information, give it to the detectives, or to be the one doing the most thorough searches, not knowing the details of the case?
It was to get, well, first of all, it was maintain the integrity of the original evidence, get copies that we could use going forward for any additional research we wanted to do, and then give that information to the investigating detectives who knew all the details of the case and the people involved.
And you may not even be aware of this, but just asking to follow up based on the defense's questions. Were you aware that, or do you know if other detectives looked at stuff on the logo and actually found other things relevant to this case?
I believe they have, because there were other detectives assigned to do some of the devices.
Okay. So just saying because you didn't find something doesn't mean it wasn't there.
Correct.
There were some questions asked about, I know some photographs of Cooper in a car seat and things like that. And just to clear this up, you stated that as up until at least May 24th, 2014, as far as these photos. Tell the jury, what is that about? What was the date listed for some of these photographs on the computer that allegedly belonged to Leanna Harris?
They had dates on them as late as May 29th, 2014, and May 24th of 2014, with pictures of Cooper in rear-facing and front-facing car seats that were on Leanna Harris's computer.
Okay, and this wasn't on a camera or a phone. This is an actual computer, right?
Yes.
Okay, and did some of these pictures, which had the same creation dates, did the child look different ages during this?
The child did, yes.
Okay, so could these been older pictures just downloaded to the computer as a backup from the phone?
It very well could have been,
Okay.
or downloaded to be saved.
I believe defense counsel asked you early on, a while back on a cross-examination about whether there were searches for divorce or marital problems or anything like that. In some of these items that you found on Leanna's MacBook, some of these documents, did they actually evince issues that there may have been marital problems and difficulties going back years?
Well, I did find one that had something to do with marital issues.
And specifically with, just to make sure we're clear here on the iPhone 5, did you do any searching of that phone other than that minimal initial search where you did the contacts and messages, things like that, and then found the name and contact information and call logs that you provided the detective?
You know, that was the extent of the research and analysis I did on that. The rest was all turned over to the investigating detectives.
It would have been on them to coordinate having other people look at the phones, look at computers, and see if there was anything specific to the knowledge they had in the case.
That's correct.
Two other things. Just to clarify, the child free was on the defendant's work computer, right? I just want to make sure that was, we may have got it mixed up between Leanna's or the defendant's Lenovo.
It was on the defendant's work computer that's owned by Home Depot.
Okay, and that was that the Lenovo?
Lenovo T530, yes.
Okay. And just because this was introduced the other day, just to make sure we finalize this, looking at Stacy's Exhibit 297 that's been admitted, you recognize that?
Yeah, these, I believe, are there's 7 blanks, DVDs, and 1 DVD with data on it.
Okay. And looking at these blank DVDs and the one that had some data on it, was there anything you found relevant in this?
Nothing that seemed of evidentiary value.
And all this stuff was available, though, for detectives to go back and see if there was, other than your cursory review?
Yes.
Okay. That's all I have, Judge.
Detective Yeager, you talked about some of the items of interest to you that you found on the Apple MacBook, and we even specifically discussed the photo of Ross Harris that you believe he took at work.
Yes.
And does that fairly and accurately depict a printout of the forensic analysis report
It does.
specifically of that photograph?
Yes.
I'll move D33.
No objection.
Admitted.
I publish.
Yes.
This was an interest in your investigation, correct?
It was, yes.
You would agree that it provides evidence relevant to the relationship between Ross and Cooper Harris, correct?
I would imagine, yeah.
Ross and Leanna, right? Their love for their child.
And their contact during work hours as well.
On redirect, you were asked about this poem of infidelity, the document about marital problems on Leanna's computer.
Right.
Fair to say that appears that this is no secret to Leanna Harris, the user of that computer.
Evidently not.
Some items of evidence, you did a thorough analysis. Some, you just passed it to someone else for them to do. Is that true?
As far as items of evidence, no, that's not true. With every computer, the internet evidence files, there's 2 things we do. first we do the copy to get the image. Then we run Internet Evidence Finder, and that looks at all artifacts that have to do with Internet activity.
Okay.
Okay? All of those for all the computers were turned over to the investigating detectives.
Okay.
The further analysis that we would do would be looking for additional items beyond Internet artifacts that they wouldn't have the ability to do, mainly because it takes a lot of computing power to run that process. Okay? So there was additional work done on some of those computers to look for that additional evidence.
As far as the iPhone goes, Ross's iPhone, 5S, is it fair to say that you pulled the information off of it? You didn't really analyze or review the information on, all the information on that device, but the exact copy, byte by byte, was given to someone else, another detective to review and analyze?
What was given to the investigating detectives was the Celebrate UFED report that you had up that you were able to search on.
Right.
They're able to do the same searches. So they're doing that off the copy and the report that was created from that copy. So that's what they're doing the research from.
Okay. You're not doing follow-up investigation. You're not doing in-depth analysis of the context or the truth of items of evidence that you find on the computer or the phone.
Correct.
That's someone else's job.
Right.
Okay. When you specifically noted the child-free visits on the Lenovo work computer, okay, wouldn't you have been looking for child-free on every other device that you were analyzing?
More than likely, yes.
And you didn't find them?
If I had found it, it would have been in my report. If I didn't find it, it wouldn't be in my report. And if I didn't run it, it wouldn't be in my report.
You ran a search for child-free. We know that.
Right.
So it
On one
can't
computer.
be one or the other. You didn't find it.
Or I didn't, but more than likely, I didn't find it. Right.
Thank you.
Hate to get back up again. All right. This photograph, they created, when was that on the photograph here where he's at work messaging his wife?
It was 10/28/13 at 10:30 p.m. That was more than likely when it was downloaded to the computer.
So it could have even been earlier than October, 2013, right?
It could have been, yes.
Okay, and the document he talked about saying it was no secret to Leanna from this old document that they had some problems in the marriage, maybe infidelity,
Right.
or it was about infidelity. Did it say anything about prostitutes or messaging underage girls?
I don't recall.
Okay.
I just know it was problems in the marriage.
So you don't know if that was a secret to Leanna, do you?
I don't.
Okay, that's all I have.
You're excused.
Thank you.
Let's take our afternoon recess. Close your notepads, take them with you, keep an open mind. No conversations about the case. Y'all step out and enjoy your break.
Judge, for scheduling, maybe
As soon as they're gone, we
Oh,
can
yeah.
talk about it. That's what I was gonna do. I won't
Okay.
go anywhere.
Please watch your step going down.
I was gonna remind y'all that we need to wrap it up between 4:30 and 5. What did you want to address with me?
Oh, Judge, I was gonna say, we actually have, we have 3 witnesses here. We have one who did one device which nothing was found on. We have, or that she found nothing on, didn't even search. We have 2 other witnesses, and they both, if we could stay to get them done, I don't think they're gonna be that long, but they came down specifically from Atlanta. So,
Can we ask who they are?
yes, Daniella Doerr and Ralph Escamilla.
Well, I think that's gonna take a little while.
childcare issues.
I understand.
Just coming in earlier.
Yes.
We cut lunches down to pretty brief. I told them to take a quick break.
Yes,
They have to go upstairs and downstairs. Let's see if we can do it in about 25 after. ready for, we need to wait for the defendant.
He's
Oh,
here.
he's here. Bring the jury.
Okay, bring him in, Joe. Yes, sir. All right.
I'll straighten that chair out on the way.
Oh, the quick chair? There you go. Per deal.
That's it.
All right. Speedy reading, got it. You do it. Joking and jiving? I guess.
I'm here to make sure you don't fall.
Next witness.
They would call Pam Colson.
You do solemnly swear upon your testimony you shall give to the court and jury on that you're not going to be the truth, the whole truth, and nothing but the truth, so help you God.
Be seated, please.
Good afternoon. Would you please introduce yourself to the ladies and gentlemen of the jury by telling them your name and spelling it so the court reporter gets it right.
Hi, I'm Pam Colson, P-A-M-C-O-A-L-S-O-N.
And fortunately for you, where do you work right now?
I am a retired Cobb County police officer.
Okay. So you no longer work. You're enjoying retirement.
I'm enjoying tennis, yes.
Okay. Just Ms. Colson, I guess it used to be Detective Colson.
Yes.
How long were you with Cobb County Police?
I worked with Cobb County for 27 years.
And just kind of cutting to the chase, the last portion of your time with Cobb County Police, what unit did you work with?
I worked in the high-tech crime squad unit for my last 9 years.
And they've already heard about what high tech does. Generally, tell them what you did just on a daily basis with high tech.
Daily basis, we did forensics on computers, cell phones, any media that you would come in contact with.
Turn your attention to, well, let me ask you this. Did you have training to get to be working as a high tech detective?
Yes, I did. I took several classes in on computers. We used a program called Encase. I took several classes on Encase. Took classes on cell phones and on-the-job training.
And can you even estimate the jury about how many different examinations or extractions you did while as a detective there?
9 years, several hundred.
Have you ever testified in court as an expert in the field of forensic examination and analysis?
Yes, I've testified as far as doing the forensics, yes.
Okay. And how many times have you been tendered as an expert, if you even remember?
I don't know if I have, but I know I've done several testimony as far as forensics.
Okay. You testified numerous times about this.
Yes,
And is that based on your education experience and, I guess, on-the-job training doing this type of things?
yes.
Okay. You're not right to tender her as an expert in the field of forensic examination and analysis.
Judge, can I have you over?
No?
Just to make sure that I heard you, you're not aware of any previous case where you had been tendered as an expert in computer forensics?
I don't know if I have or not. I know I've testified in forensics, but I don't know if I've been tendered as an expert or not.
Okay.
I don't remember.
Okay. How long have you been retired?
2 years.
Okay. Congratulations.
Thank you.
In your time with the Cobb County Police Department, you said 9 years with high-tech crimes?
Yes.
Okay, so 9 years in performing the duties of a computer forensics expert?
Yes.
Okay. Judge, I don't have any questions.
She may so testify.
All right, Ms. Colson, going to, back in June of 2014, were you asked to help as far as doing an extraction on a device regarding the death of a child named Cooper Harris?
Yes, I was.
And was this just one device that you actually did some work on?
Yes.
I'm going to show you what's been marked for identification purposes as State's Exhibit 303. recognize this?
Yes, I do.
How do you recognize it?
From check mark in the front, it's packaging for the MacBook Pro and my initials on the back.
And does that appear to be, is that the exact same computer that you would have done the extraction on back then in 2014?
Can I go?
Yes, absolutely. Yeah, you may need to actually pull it out of the bag to make sure.
I'm sorry, I'd have to get my glasses out to. Yes.
Your Honor, I would tender State's Exhibit 303.
Any objection?
Can you check with the clerk? My records indicated it's already in that.
Actually, I think it has been admitted, Judge, it just hasn't been shown as it is. We'll keep it as well.
Is that correct? It's in evidence.
Ms. Colson, tell the jury just what type of analysis you did on that computer.
On the computer, I removed the hard drive and did a bit-by-bit copy of the hard drive that was from the computer. Looked through pictures, folders, looked for deleted files, just the basic, look through the computer and see what's there.
Okay. Now, did this involve internet searches or anything like that, or is that something different that you created for other people to look at?
I did do an internet evidence finder. Once that program ran, I put it on a disk, placed it in evidence for the detective to review that information.
And when you just reviewed like documents, things like that, did you find anything of note on that computer as far as documents and just things of that nature?
No, I did not.
Okay. And the actual computer, I guess, internet evidence finder, you left that to the detectives to actually go through and see if there was anything relevant, correct?
Yes, I did.
I'm going to show you what I marked for identification purposes in State's Exhibit 322. Yeah. Okay, detective, showing you State's Exhibit 322. Do you recognize this?
Yes, that's the disc that I produced and placed in evidence.
Okay, and how can you tell that it's yours?
My initials and bad handwriting.
Your Honor, I would tender State's Exhibit 322 at this time.
No objection, subject to the issues in the present project.
So, same objection, whatever, same ruling.
That's all I have, Judge.
Cross?
Your responsibility in this case was to perform the duties of a computer forensics expert for the Cobb County Police Department for one device.
Yes.
And that one device was the Apple MacBook Pro.
Yes.
Okay. And that Apple MacBook Pro, as your understanding, is different than Leanna Harris's Apple MacBook Pro that someone else with your unit examined. This one was specifically Ross Harris's, correct?
That's correct.
Do you have your report?
Yes, I do.
Okay. And because you only worked on one device, you don't have many reports in this case, correct?
this report, yes.
And you reviewed those reports before testifying today?
This report, yes.
Okay. You prepped with the district attorney's office,
Yes.
correct? Fair to say that having been retired for a couple of years, perhaps your memory about your work in this case has faded over time?
Oh, well, yes, I mean, that's why I review the report.
That's why you, okay. And you needed them, right, to refresh your memory about what you did?
Yes.
Okay. Now, you assisted Detective Yeager with the analysis of this computer, the Apple MacBook Pro.
Yes, he asked me to do this computer.
Okay. Now, is there a chain of command within your unit where Detective Yeager would have been responsible for delegating responsibilities like that?
No, we worked as a team.
Okay.
In any case that had a lot of computers, cell phones, we'd assist each other.
Now, is this the kind of case that you would consider as having a lot of computer devices or electronic devices?
Anytime you're dealing with computers or cell phones, anything over 2 is a lot. It can take time. When you're looking at 500 gigabytes in a computer, that takes time. So,
And in your 9 years with this unit, having close to a dozen electronic devices, that's a significant amount, correct?
yes,
Ross Harris was a web developer. Do you know that?
if you say so. I don't know anything about Mr. Harris.
You don't know anything about the investigation?
Processed his computer. That's really all I know about Mr. Harris.
Okay.
I believe he works at Home Depot. That's all I know.
Fair to say, though, that in high-tech crimes, you can learn a lot about a person about their activity on their electronic devices.
That's true.
Okay? And that was your function, is to look at this computer, correct?
That's correct.
Now, you were specifically informed of the allegation that Ross Harris had researched on the internet, he and his wife had allegedly researched on the internet, or told detectives that they had researched on the internet in car deaths, correct?
I was told from their interview, I mean, not exact, but I was told from their interview that it was mentioned about car deaths.
Okay,
And to check the computer for that. I can't give you verbatim what the detectives told me 2 years ago, but they'd learned in an interview that they had done searches for that.
Well, to the best of your memory, what did detectives tell you to assist you in what to look for on these devices?
They wanted internet history, which I provided,
Okay.
and anything relating to the crimes of murder and car deaths.
And in your report, you specifically indicate a search warrant, right? Because in order to go into a device, you got to have a search warrant.
That's
right?
correct.
And the search warrant sets parameters, sets limits of what you can look at and what you can't, right?
That's correct.
Right. And in this case, you were told to look for evidence that would be relevant to murder, correct?
Correct.
Cruelty to children,
Correct.
okay? And then specifically, because you mentioned having to rely on this search warrant, 14 SW 0609, you were informed that allegedly Ross stated that he recently researched through the internet child deaths inside vehicles and what temperature it needs to be for that to occur, correct?
Okay, yes.
That's right. And so in specifically crafting your examination and analysis of this computer, you're able to, well, in fact, you reviewed, searched internet history, documents, and a keyword search. What were the keyword searches that you performed?
Well, the keyword searches would have been, it'll be on the actual report, but it should have been murder, child cruelty.
Okay.
Simple word is child. Cruelty, you know, you're going to break that down to look up different ways of,
It should be on this report,
that I believe is the,
the IEF.
that is the, no, that's the Internet Evidence Finder.
Okay, so what report contains the keyword search terms that you use to examine that computer?
That will be on the hard drive that has the evidence files on it. There was no report produced on this because there was no notable files found. The Internet Evidence Finder, that was downloaded, placed on that disk for the detective to review. I didn't locate any notable files as far as child and murder, car deaths, so there was no report generated. But there is evidence files.
Well, what I'm asking is, what report has the keyword search terms that you use to examine and analyze that computer?
I'm answering your question. There was no report generated on that. There is evidence files, but there is no report generated. The only report that was generated was the Internet Evidence Finder, which was provided to the detective for his review.
So how do we find out exactly what keyword searches you use to examine the Apple MacBook Pro?
We'd have to bring up the evidence files.
And where are those?
They're probably at high-tech crime unit as a backup.
They're in Cobb?
I'm assuming. I don't have them with me now.
So you didn't review those evidence files before testifying?
I reviewed my report here. Like I say, I found no notable files, so a report was not generated on what I did on the forensics. I know you want specifically what did I look for?
Sure.
Murder,
And we'll get to what you
child,
found. Yeah.
car deaths.
We'll get to what you found. I'm specifically asking, how do we find out? How does the jury understand what search terms you use?
Objection, asked and answered a few times, Judge.
I know I've asked it several times, Judge, but it hasn't been answered. She's told me that no notable files were found. That's not my question. We're going to get to that. I'm asking about the keyword search terms that she used to examine the computer.
Well, she has testified to that, so I sustain the objection.
Thank you.
You searched for murder, cruelty to children. Okay. Do you remember anything else?
No, I do not.
Okay. Having been advised that Ross had allegedly researched through the internet in-car deaths, naturally you would have searched for that, right?
That's why I did the Internet Evidence Finder and downloaded that to a file for the detective to review. They're familiar with the case, so that was sent to him or her to interview, to look through the report.
Now, but you go through it as well, right? I mean, you examine and you look through the Internet Evidence Finder program, right?
On this particular, no, that file was ran, it was placed on the disk and placed in evidence for detective review. They know what they're looking for specific. On computers, with pictures and all, there's a lot of pictures you can have on a computer. So yes, we'll assist and we'll go through those because, that's kind of hard to put on a disk, 500, That's a lot to keep doing disks. But Internet Evidence Finder, they can put that in, they can look through, they know what they're looking for and they can find what they need.
The report you created, you didn't go through?
As I stated, I ran the program. I downloaded it to that disk once the program completed. I placed that disk on a property control record. It was placed in evidence for detective review. Detective knew what he was looking for. They can look through that portion of the evidence.
Okay. Did you not know what you were looking for?
Once again, they know the specifics of what they're looking for. I could use my time better to go through, look at pictures through the internet, because like I say, that's a lot to put on disk when you got 500 gigabytes of items that you're going through That's a lot for them to put on disc for them to look at. They want, even in an internet evidence finder, I place it on a disc, they review it for their evidence.
The following is a list of items that you reviewed and searched during your analysis.
Objection, Judge, that's misstating what it says. It says and/or.
You want to rephrase?
Sure. The following is a list of items reviewed and/or searched during the analysis. Recovered folders for each volume, correct?
Correct.
Sweep case, correct? File structure for compound compressed files, correct?
Yes.
Gallery review, that includes JPEGs or photos and videos, correct?
Correct.
Internet history, correct?
Correct.
Document review, correct?
Correct.
And IEF, Internet Evidence Finder, reported, placed in an HTML report. That's this, correct?
That's correct.
All right. And according to your report, you reviewed and/or searched this item.
According to my report, what you just stated, placed in an HTML report, and/or that was placed in an HTML report, and it was later placed on Property Control Record 250429 for detective review.
This is one of the things that you listed as having searched and/or reviewed, correct?
Look at the report. It says placed in an HTML report, and/or, I don't know how to answer your question.
It's very simple. You reviewed that report because
No, I
your
did
report
not.
says so.
I did not review that report. I told you. I downloaded it, put it on the disk. It was for the detective review. I don't know what's on there. Unless it was in some kind of gallery review when I was looking at the computer, then I would have seen some of the things that may or may not be on that disk. I don't know what's on that disk.
When you write a report, in 9 years, it's your experience to be accurate, correct?
I feel that I was very accurate in what I reported there.
Your conclusion is that during the analysis, you did not locate any notable files. Your testimony is that you did not look through this, correct?
That's correct.
Yet your report says that you did, and there were no notable files of interest inside of it.
My report does not say that.
Okay. Let me get a clean copy.
Here you go.
Full report.
Oh, I got the third page. Here you go. Sorry.
Judge, I'm showing the stake what's been pre-marked for identification purposes is defendants 34. This is your report, correct?
That's correct.
Is that a fair and accurate copy of the report you generated on this case?
Yes, but I didn't highlight the numbers, the dates that you have highlighted.
The content of these is not any different from the content of your report that you're holding in your hand, correct?
That's correct.
I'm gonna move D34.
No objection.
After running keyword searches on this computer, you found no notable files. Permission to publish?
First of all, I'm going to object because that wasn't a question. You just made a statement, tried to tender something or publish something, so I'm going to object to the question. It's not a question.
Sustained as to form.
You'd agree that the last item that you reviewed and or searched during the analysis in your report is a keyword search?
That's in the list. Yes, that's in the list. It's the last thing on the list.
And the results of your forensic analysis is that you did not locate any notable files, correct?
Me personally, I did not locate any notable files
On the Apple MacBook Pro,
on the Apple MacBook Pro.
Ross's personal computer, correct? If there was pornography on that computer, it wasn't notable to you.
I wasn't aware that I was looking for pornography, but no, it was not notable to me.
You looked through it. You found no notable files.
That was not notable to me. That is why I provide the detective with the Internet Evidence Finder so he can find his notable files. They know what they're looking for. I get a general idea of what they're looking for, but they know best what they're looking for as far as the Internet, because that was of interest.
Just a second. Thank you.
Nothing further, may she be excused.
Yes, you're free to go. Next witness.
State calls Daniella Doerr.
You solemnly swear from the testimony to the court and prove that you not communicate the truth, the whole truth, and nothing but the truth.
Have a seat, please.
Ma'am, would you introduce yourself to the ladies and gentlemen of the jury by telling them your name and spelling it so the court reporter gets it correct?
My name is Daniella Doerr, and you spell it Daniella Doerr.
Okay. And Ms. Doerr, without telling us your exact address, where do you live generally?
I live in Ackworth.
Okay. We're down here in the south of South Georgia. Tell the jury where Ackworth is, what county it's in.
Ackworth is actually considered Cherokee. It's in the Tri-County area. It's about an hour away from Atlanta on the north side.
Is it near Cobb County?
Yes.
It's part of Ackworth actually in Cobb County?
Yes, Tri-County area.
All right. Back in 2014 in June, where were you living?
I was in Marietta on Franklin Road.
And were you living in Franklin Road?
Yes, I was. I was staying at the Econo Lodge.
Okay. Now, not meant to embarrass you or anything, but tell the jury what kind of work you were doing back in May, June 2014.
Due to unseeable circumstances, I had to associate myself with Backpage in order to make it to where I am now.
Okay. Now, our jurors may not know what Backpage is, but...
It is an escort service.
Okay. And as an escort, did you perform sexual acts for money back then?
Yes, I did.
Okay. I'm going to turn your attention well, first let's start with Backpage. Are there different types of sites that you could use back then when you were having to do this to advertise?
I struck strictly to Backpage.
Okay.
I wasn't really aware this was my first time actually doing anything of that nature as far as going on the internet and publicly advertising something that way. That was the only site that I knew of.
Now, when you advertised on this website, did you actually did you post a phone number?
Yes, I did.
Do you remember that exactly off the top of your head?
Not the last 4 digits. I'm familiar with the 678.
Okay. If I showed you a copy of a report, would that refresh your recollection? If you saw the number, would it remind you if it was yours or not? Okay. Please, each one of y'all. You talked about a 678 number. Let me let you look at this real quick. Looking at that, does that refresh your recollection about what number you were,
Yes.
and what number were you using back then?
I was using that number that was posted with my ad. That was the only phone number I had.
Okay, just for the record, is that 678-360-0318?
Yes, sir.
Okay. So tell the jury a little bit how that would work when you posted your phone number on an advertisement.
Initially, my number would go on the ad with a couple of pictures, just a couple of face shots, just to let it be known that it was me, along with a number that allowed the person, whoever needed the service, as it was put kindly, they would call me. They would come to me. I would not do outcalls, which is where you go to the person and meet up in their environment. That was something I didn't engage in. It was very sketchy already given the circumstances of the business. So with my phone number, that was a way for you to contact me, to come to me, so that I could feel at least somewhat dignity or comfort doing what I was doing. So.
Now, during this time when you were doing this, let me go ahead and jump to September of 2014. Did you get a call to respond to a hotel, and you showed up and it wasn't what you thought it was going to be?
Actually, I got a call, and I told them on the call that they had come to me, and they actually did come to me.
Okay.
So.
Okay. And in September of 2014, who showed up?
Initially, it was a Hispanic gentleman, and the Hispanic gentleman told me that he had left the money in his car, and we proceeded to go to the door, and that's when I figured out what the real reason was.
Was it the police?
Yes, there was an armed officer at the door.
Okay. So obviously, when this happened, were you afraid you're about to be busted?
My words were, I'm going to jail.
Okay. Were you on probation at the time?
Yes, I was.
Okay. Now, when they approached you, first of all, did they talk to you about, did they say they were going to arrest you for the prostitution? Or,
No.
Okay.
They did tell me that it was pretty much a ruse just to get to me, to talk to me, because apparently my number had been seen in the cell phone or whichever records that had acquired my number on it. They did ask me if anything was in the room that I shouldn't have, and I openly admitted that I did have marijuana. They never saw the marijuana, but clearly from the smell of the room, you knew I had it. So there was no reason to lie.
Mm-hmm.
But there was no, you're going to go to jail if you don't talk to us or anything like that. It was, this is how we got to you. Now can we talk to you?
Okay. Did you agree to speak with them?
Yes, I did.
Okay.
Being on probation and knowing the situation I had myself in, the best bet for me was to be cooperative.
Did they in any way, did they tell you what the focus of their investigation was? Like what type of crime they were investigating or anything like that? Or were they just interested in a specific person, if you knew?
They asked me if I had seen this person. They showed me just the face shot. And automatically I knew what it was because clearly by that point it had been on the news. I really hadn't watched the news too tough.
Mm-hmm.
You know, I had heard fleeting rumors and hearsay gossip about what was going on, but as soon as I saw the picture and it was like, yeah, I had seen him a couple of times, that's when the broad scheme of what was going on had came to play.
Okay. So the first part when you recognized him, was it because of your interactions with him in May personally?
Of course.
Okay. And then later you kind of realized what it was?
Yes.
Okay. I'm going to show defense counsel marked for identification purposes as State's Exhibit 323. Showing you State's Exhibit 323. Do you recognize that?
That was the picture.
Okay. And does that look similar to the picture they showed you?
Yep.
Your Honor, tender State's Exhibit 323.
Objection based on our subsequent motions in this matter.
All right. Allowed over objection. Prior ruling stands.
Thank you. Just permission to publish briefly.
You may.
Thank you. Now, when they showed you this picture, Did you immediately say, did you say that you thought you recognized this guy?
I was very confident that I recognized him.
Did you give him a percentage at the time?
Oh, yes.
What was
I was at least 90% sure because
And was this, let me ask you this, was this before verifying any phone numbers or anything like that?
oh yes, most definitely.
Okay. When they showed you this photograph, did you tell them about encountering him back in May of 2014?
I knew exactly who he was once I looked into the picture and they started telling me because he actually came to me the week of my birthday, which is in May.
And as far as this sticking out to you, let's start, what hotel did you work out of back in May?
The Econo Lodge.
Okay. And back in May of 2014, do you, why did he stick out amongst everybody else? There's something different about him than most of the people that you would see?
It's not that. It's more or less in that business, you have a memory. You can't block it out unless you just completely lose your whole self in that. And on a personal note, I do not prefer white men, so they do. I have to remember that.
Okay. So you usually were engaging these things with African American males?
Yes.
Okay. So did he stick out because he was a white guy?
Not only that, but just given the circumstances of hearing everything and then going back to those 3 times that I saw him beforehand, there was never any nervousness. It was always like he was very relaxed. Nothing was ever going on. He really didn't talk about much. It was more or less strictly business and then go on your way.
And when you saw this picture, how, did you describe to the police or describe to the jury what you remember about what happened? What type of acts and things like that?
It was basically regular vanilla sex, you know, no crazy fetishes, no nothing. The first time I remember clearly was a quick visit, which is 15 minutes, just to grab bearing of who you are and who I am, to make sure I'm not a police officer, it's not a sting. The second time was actually a little bit longer, 30 minutes. The reason the way I was able to describe him was just, he didn't have any presence about himself, like he just didn't care, very dumpy, just, you know, a little bit overweight, a little bit on the hefty side, you know, he just really didn't care about his appearance. You can just tell.
Now, when you have something like this, when you have a person that comes to you for these services, are there any usual amount of times or contacts that you have with the person before they come to the room?
Mainly it's minimal contact. It's mainly just where I'm at, who you are. It's very quick sort of questioning, you know, no affiliation. At the end, it's still based upon them coming to your room or you going to them, which in my case was not an option.
Do you remember how many times he would have called you before he would have arrived?
He'd call
If
me.
you do.
If he'd text me the first time and ask me, you know, hey, are you available? And I would tell him yes or no. And then he'd call me to let me know that he was there, because at the Econo Lodge, you actually had to be, you had to stay there in order to get in. You had to have a key card. So I had to let him in because I had to walk to the end of the corridor to let him in from the outside. So I would get called at least twice. Once to ask if I was available, the second time to let me know when they were there so I could let them in.
Did you actually engage in sexual acts with him back in May?
Yes, on 3 different occasions.
Okay. Now, were you actually asked to look up, or did you volunteer to look up the phone number that they gave you for him?
I did at the time.
For a May 31st incident?
I did. I had Sprint at the time, so I was able to pull up my phone bill directly on my phone, and I highlighted every time he called my phone.
Did they give you a number, and did you look at it and verify you had gotten that?
Yes, we verified it between my phone bill and what they showed me.
Now, I know it's been a couple years since you went through this. Have you gone through some stuff in your life? Okay. When you talked to the police back in 2014, do you think your memory would have been better then or better now today? No, it's maybe a tough question, but...
At that time, honestly, I would have to say it'd be about the same because, you know, since that point in my life, I've done nothing but get better. I became a mother myself, finally. You know, my daughter was born 3 months early, so I've gone through a lot of different good things. So, you know, I try not to think about back then, but I keep a hold of that because it shows me what I overcame.
And with all this, with everything you said about this, the police actually came to you with his phone number, right?
Yes.
And they saw verified on your bill that it was his
Yes.
number that contacted you, right?
Yes.
Okay, that's all I have. Thank you.
Hey, good afternoon, Ms. Doerr.
Doerr.
Am I pronouncing that
It's Doerr.
correctly? Doerr.
Doerr.
Okay, sorry. All right, so I first want to ask you a little bit about your using Backpage. Is this is it a written newspaper or is it an online
It's
newspaper?
an online ad.
Okay. How long had you been using Backpage?
By the time that they came and saw me, it only had been since April, end of March, beginning of April, but it had just gotten down to Cobb County.
Okay. March or April of 2014?
Mhm.
Okay. All right. And I think you said it was your birthday?
The week of my birthday, yes.
Okay. All right, do you remember going over your phone logs with them that it was May the 31st of 2014?
I'm not completely sure about the date.
Okay. May have been end of May?
I know it was definitely in May.
Okay.
Because the first time he did see me was the week of my birthday,
Which is when?
May 18th.
Okay. And when you said first time he saw you, you said it was 15 minutes?
Yes.
And this would have been the week of May the 18th?
Yes.
And was it the same location at the Econo Lodge?
Yes.
Okay. And the only way that he would be able to locate you was your phone number on Backpage?
Yes.
Okay.
Because before then, I had never seen him a day in my life. I'm not even from the area.
All right. So, did you take a look at your phone record to see if the same number was on the 18th?
Yes, I did.
Okay. And so you said that was 15 minutes, and then the next time you saw him was when?
30 minutes. I'm not sure about the second time. I just remember the first time specifically because when I was talking with him, that was what stood out because of that week of my birthday.
All right. And you talk to people regularly without actually having a date with them, right?
Back then, yeah, you had people call you and ask questions.
Sure.
You had a lot of people no-show. Sure.
Sure. Or shopping around.
Yeah.
See what you were into, how much you would charge, what
Yes.
the circumstances were, just sort of feel you out.
Generally, it wasn't really discussed on the phone because, never knew what was on the other
Sure.
line. So that kind of information, you just really didn't really give out.
Right. But the bottom line is just because someone's phone number appeared on your bill doesn't mean you necessarily met with them that day.
You can make that assumption, yes.
Okay. And you kind of had a little procedure where if you were actually going to meet with somebody, there would be multiple calls right together, right?
Not multiple. You would call me the first time, you
Okay.
would set up your appointment, and the second time would be when you would get there. So it really wasn't multiple times unless you just got lost or you didn't know where you were going.
Okay. So what kind of direction do you give your customers?
I sent them the address so you could GPS it.
Okay. And do you tell them when they get to the motel
They call me.
that they're to call you again?
Yes,
Right. Just once.
yes.
All right. There's not a second call?
There's 2 calls in total. First
Okay.
time when you call me to set up the appointment.
All right.
The second time would be when you would get there, so I had to let you in because you couldn't get in. It was not a free access hotel.
All right. Were you working any other motels besides the Econo Lodge?
For a momentarily stay, I had worked at the one across the street, but
Ramada?
I believe that was the name at the time.
Okay.
They've now changed it so many
Right.
times.
All right. That was the And it's off of Franklin Road?
It's right across the street from the Econo. They were doing
Okay.
renovations at one point, and I had stayed over there for a couple of days and went right back to the Econo.
All right. So when you were working the Ramada, if your customers called, you would direct them to that motel?
Yes.
All right. And you think you've been working Cobb County since March or April of 2014?
At that time, yeah, it was.
Okay. And prior to that, you were from the Rome, Floyd County area?
Bartow.
Bartow. All right. And what motel were you working in Bartow County?
I didn't work up there.
You weren't working there? Okay.
That was a choice I made after, some things had happened and I had lost everything that I owned. That was a way for me to survive, not having any family in the United States.
Okay. How did you learn how to post an ad on Backpage? Did you have a laptop or something and just started
Phone.
investigating it?
I had a phone, word of mouth, by the time I got down to that area, just figured I'd try it, give it a shot.
Well, I don't know, and that's why I'm asking. Did you
It was
have
word of mouth.
some other friends who were in the same business?
I had one female friend that was in the same business, but she's not the one who taught me about it. Like I said, I had heard through it word of mouth, and it was a decision I made all on my own.
Okay. So you were just sort of self-taught how to get online or get on the phone and place the ad on Backpage.
Pretty much I figured out how to do it by myself.
All right. And was it always the same ad? I mean,
Yes.
did it look the same? Did you change it up any?
No, not that I believe. That was one, that's one thing you kind of had to keep in mind back then. If you keep changing it, people would be sketchy to come see you.
Okay. Well, did you have regular customers then they had your phone number, so, they would come on a regular basis?
Yes.
All right. How many regular customers do you think you may have had?
Not a clue.
No. Okay.
I did what I did to survive, not out of greed, so it's not like I took
I'm
everybody
not
that came to
judging.
me. So.
I'm not
No,
judging.
no, no.
Okay.
I didn't take every caller that came to me. I did what I needed to make sure that I was okay.
Okay. And all right, during this time period, and again, this isn't meant to embarrass you or anything, but just to kind of give us an idea. How much work were you doing? A couple of customers a day or something like that?
I would have a goal of at least 3 or 4 a day to make sure that I could pay for my room and be fed and take care of my personal belongings. That's why I said I didn't do it with greed intentions.
Okay.
I did it solely and based upon what I needed for the day or for the week, however I planned it.
All right. And did you always do it at 30-minute blocks of time?
No, I did 50. You had a choice of either 15 minutes, 30 minutes, or a whole hour. It was depending on what you paid for.
Okay. And most of the times, it's fair to say it was usually half hour.
Most of the time, it was actually quick visits. That was generally the money maker, as you should say.
Right. Okay. And the half hour was $1.25.
Yes.
$125.
Yes.
Okay. And I'm assuming you just took cash?
Mhm.
All right. All right. And your recollection, you said it was strictly business and on his way.
Yes.
All right. We're just talking about sex.
Yes.
Okay.
I'm not your psychiatrist. I'm not your therapist. You came to see me normally because your wife wouldn't shut up.
Right. We're not talking about the girlfriend experience.
Exactly.
Okay.
I didn't want to know about your kids. Didn't want to know about nothing. You came in, you got your pleasures, your jollies, and you went about your way.
All right. And well said. And I assume that you probably had customers in all walks of life in that area.
Most definitely.
And when that area, that's right off of Interstate 75.
Oh, yeah. You got every religion, every race, every color, everything.
Right.
So,
I know that must have been difficult, to say the least, but you saw across a wide spectrum of men,
yes.
white and black,
Yes.
younger and older,
Yeah.
and middle-aged like me.
Yes. That was the prime retail.
That's the problem.
That was the prime retail.
Because they were working age and they had money.
That, and they had been in a relationship for a while, and, you know, stress, and I guess after 10 years or 15 years, y'all go about your way.
7-year itch?
Pretty much.
Okay.
That's what you could say.
And that was your job. You were there to do that business,
Yeah.
and you had plenty of customers that came through the door.
Yes.
Okay. Working guys, blue collar, that had $125. And guys like me in suits.
Most definitely.
Okay. And everybody in between.
Yeah.
Okay. And other than the fact that he was white, I mean, there was nothing particularly remarkable about him.
No, I mean, like I said, you know, not only because of the fact that he had been a repeat, and repeats tend to stick out a little bit more. It just, like I said, he just took no care in his appearance. Certain things like that, being how I am OCD as far as like appearance-wise and cleanliness-wise, those are things that do stick out to me.
Okay. Now you told us you were on probation at the time.
Yes, I was.
All right, and was that for marijuana?
Yes.
All right. Bartow County? You were on probation in Bartow County?
Yes.
At that time?
Yes.
Okay. And the officers that came in, they let you know right off the bat they knew you were on probation?
No, they didn't say that.
They did not?
No.
Okay.
But like I said, being in the situation that I was, when the question was asked, do you have anything in here you shouldn't have, there's no sense to lie. The smell gave me away.
Right. The smell being marijuana?
Mhm.
All right. Did you have marijuana out on the table that you were
They never saw it.
smoking? They never saw it?
No.
All right. What did you say about the marijuana smell?
I just said that I had, when they asked me if I had anything in the room that I was not supposed to have, I let them know.
All right.
Simple, clean cut answer.
And you let them know? You said, hey, I got some weed in here. And did they ask to see it?
No.
They just said,
I think the
Ask
main
no
question
questions,
was
take no-
basically to ensure that I didn't have any weapons or firearms in the room, which I didn't.
okay. Bottom line is, they knew you had weed, and they didn't ask to see it, and they didn't see it. Okay, they left your apartment, and they left the weed behind.
Mhm.
Okay. And I'm sure at that time you were breathing a big,
I shut down business the rest of the night. Let's just say we sat in the bed and we was
Took a
a nice little country girl and just sat and watched TV all day.
okay.
That kind
It
of
scared you?
shell shock. Yes, it did. It shell shocked me. I'm not even gonna lie.
When did you, you're not doing this anymore?
No.
Okay. When were you able to get out of this?
Yes.
When?
Oh, when I actually found out I was pregnant. Right after the officers came and saw me, not even 2-3 weeks later, I found out I was pregnant, and given my history with pregnancy, I gave it all up.
Okay.
I got out of town.
Good for you. All right. Did you drive down here today?
Yes.
Okay.
No, I drove down
You
yesterday.
drove down yesterday?
Yes, I took that nice little 5.5-hour trip.
Okay. And they were nice enough to get you a hotel and all
Yes.
that? All right. Are you gonna turn around and go back today?
I'd like to. I want to go back to my
Did-
baby.
All right. Did you bring you didn't bring your baby with you?
No.
Okay.
I don't want to, no.
I think that's all.
She's almost 2. Would you bring her? Yeah.
Mine's 15. I think that's all I have. Best of luck to you.
Thank
I
you.
mean that.
Just one follow-up, Judge. Ma'am, do you recognize the person that you were talking about when you talked to the police and described having sex for money with him back in May of 2014 in the courtroom here today?
Yes, I do.
Okay, can you point to him about what he's wearing and
He's wearing the green suit in the middle between the 2 gentlemen right there.
Your Honor, I ask the record to reflect that she has identified the defendant in this case.
Record Ms. Overflow.
Thank you.
Judge, if I can have just one,
Yes, sir.
Let me just clarify one thing. You said that, you said that there was a Hispanic, man who, came to the door initially, and that was the date.
That was the date, yes.
Okay, and then y'all walked to the door and the gig was up. There were, uniformed officers out there.
And there was one uniformed officer and then another officer.
Okay.
So there was 3 in total. There was 3 officers in total that came to my room.
All right. One being the Hispanic
Yes.
guy, second being the uniformed officer, and then there was a second officer outside.
Yes.
All right.
Once I saw the uniform, I knew right then and there. Well, I assumed right then and there I was gone.
Okay. And I'm assuming when y'all had the little conversation there in the, in your apartment, all 3 officers were inside the apartment?
Yes.
So all 3 would have heard the conversation, what was going on?
Yep.
Which officer told you that he wasn't gonna take your weed?
The Hispanic gentleman let me know that, hey, yeah, we're the police, but we're not that kind of police. We're here on 2 totally different, you know. We don't want to have nothing to do with that. We would like to talk to you.
But he very specifically told you.
I'm not going to jail. You're not going to jail today for prostitution, yes.
And I'm not gonna take your marijuana.
I mean, they never even asked to see it. I mean, I was very forthcoming with everything I had to say and what I needed to do.
Okay.
Anything further?
No, Judge, but you can excuse.
Yes, you're free to go. Thank you. Next witness?
We approach, Judge.
Yes. Y'all look at me, hoping I'll keep my word. I will keep my word. We have an agreement. The next witness is likely to take past 5 o'clock. It would be nice to accommodate that person since they're gonna have to travel back and forth. But we've worked a full day and we have an understanding and they won't finish by 5 and we've worked a full day. So I'm gonna excuse you all for the weekend. Come back and we'll start at 8:30 Monday morning. Close your notepads, and let me give you a little more reminders. Keep an open mind. Fairness to these parties is that you do not form any opinions about any issues in the case at all. To hear the evidence, to hear the argument, to hear the law, and to deliberate. You have to maintain your mind in an open place so that you can receive all those appropriately and be able to discuss one another the evidence and the law as you deliberate. You can't deliberate until the conclusion of all the stages I've explained to you. Keep an open mind. Your notepads can be left in your jury room or collected by the bailiff so that they'll be secured. You don't need to worry about them. Just leave them here. You can't talk to each other about the case. You've been good and careful. We need to keep on doing that. You won't see each other till Monday anyway, so. But you're going home to family and friends to do the weekend activities. We all have a variety of things, social, religious, perhaps, family, perhaps, the different things that people do on a weekend, chores, chores. When you're doing that and you're having your connection with those that you come into contact with, don't talk about the case or let them talk to you about the case. I told you exactly why that is, but let me remind you. You are the jury selected, chosen, and sworn to try this case. Only you. Only you are going to hear everything the law allows about this case in this courtroom. Nobody else. I have found even the stingiest person on the planet to be very generous with one thing, and that's their opinion when they have no responsibility at all for that opinion. I think blah, 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 well, so what? And you don't need to hear it. So just go, mm-mm, or something else, perhaps a little more polite so that you'll come back with your hand. Because there's some folks out there that if you went mm-mm to them, you might not, it might not be pleasant. But you'll know how to handle that. Just simply keep it evermost in your mind. I can't talk about this. I can't let them talk to me about this. You know, even your loved ones, to say, I love you, but I can't do it. No independent research, no independent investigations of any sort whatsoever. You're going to hear everything that the law allows you to hear about this case. The evidence of the case is coming to you as we speak. That's what you have to base your verdict on. Nothing else can come into your awareness. And as you know, if it becomes brought to my attention or something, we'll have to stop the trial and make an investigation to be sure nothing's been done along those lines. That's not how we want to spend our time. We want to try this case. So be mindful of that. No contact with attorneys, parties, or witnesses to the case. I hope you all have a wonderful weekend. I'll see you at 8:30 Monday morning.
All right, the jury. Just watch your step going down.
Any issues before we retire?
Yes, Judge, I brought
Please
up
be seated.
during the lunch break, proposed order that was suggested by Escort involving some evidence that we'd like to look through during breaks. And I now amended that order after discussing with the defense counsel. Their complaint was it doesn't itemize what particular items. And then that's a fair issue. So what I've done is I've modified the forms that we can specifically write down what items we're looking at. So at present, there are 5 items that we would like to look at over the weekend, 4 extraction discs in the car seat, and I've put those exhibit numbers on this proposed order I've shown it to the defense counsel.
What do you say?
We'd like to take the iPhone 5 with us over the weekend so that we can have an opportunity to review that piece of evidence. If the state's going to be able to take pieces of evidence out of the courtroom that are already admitted in evidence, we should have the same ability to do that. So.
And did you talk to them first?
Yes, I told Mr. Evans that I wanted, I asked him if he would have a problem if we took the iPhone out. I don't think he wants me to, but my understanding is that the state already has copies of all the stuff that they put into evidence. You know, that's why we put it into evidence. That's where it is, and they've got copies they can review. I don't know that they need the original. But, I mean, if the court's going to allow them to take original pieces of evidence out, the defense should have the same privilege. We'd like to take the phone.
What do you say?
Well, first of all, this is the state's evidence. This is not the defense evidence. And I certainly have no objection to the defense looking at the iPhone while it's in the custody of the clerk in the presence of law enforcement officers. My investigator would be happy to stay with them while they power up the phone and look at it here or elsewhere. That's always been an option that's been available to them from the outset. But that is the state's evidence. If they want to take their evidence out, they can prepare an order just like the one that we've prepared so that they can more orderly put together their case for presentation. I will point out to the court that the extraction disc take an awful long time to load up on the laptop. You saw that yourself, which creates a lot of technical difficulties. That's not original evidence. It's what's recovered from the actual device itself. So it's very limited. While we could work from copies of that, the fastest way to load that on the laptop for the orderly presentation of the evidence is to be able to have some time to actually put it on the laptop and mess around with it on the Mondo pad that we have upstairs at the district attorney's office. So I don't have an objection to them ultimately looking at the phone under a controlled context. They can look at any of the state's evidence in a controlled context, but it is still the state's evidence, so we'd object to them being able to take it out.
Well, I think we're mixing apples and oranges. I don't want to talk about the phone at this point. I want to finish talking about what the state's requested, and I don't really see quid pro quo, et cetera, going on with this. What is your objection about what the state has offered in terms of their order?
That it is already in evidence. It is not the state's evidence, it is in evidence, which is in the possession of the court and the clerk of the court. They already have copies that they can work from. What happens if a piece of this original evidence is maybe put by a magnet, or lost, or damaged, or who knows what? That's why we have the clerk of court maintain possession of the actual evidence which has been admitted. I just see no reason and no purpose for the state to take the original out when they've got copies of all this. We know they've got copies, they've given us copies.
Our witnesses won't be testifying from copies, they're going to be testifying from the original evidence. Therefore, it makes a sense for them to be able to look at the actual discs that we're going to be playing things from, and to be able to look at the other items of evidence. I mean, the only other alternative is to impose on your clerk to be involved in the process of allowing to do this, which we don't mind doing. It's just, it's kind of a hassle for him. So we were trying to do this more as a courtesy to him, because you know, he's got a weekend too. But at the same time, if you're not unwilling to do that, if the court's not willing to entertain this minor issue, then I think I can take it up with Mr. Phillips, and we'll make some alternative arrangements for some of that things.
I'm not going to sign the order. I think the defendant's arguments are valid, and I think there is an alternative, and I think Mr. Phillips will accommodate.
Thank you, Judge.
All right, what else for the state before we break for the day? What else for the defense?
Once the state has had an opportunity to take a look at the proposed charge, and the court has had an opportunity, I'm fine if we take that up Monday morning. It doesn't have to be done now, but that's the only other thing outstanding that I'm aware of.
Well, they may be ready. I don't know. Have you all had a chance to review?
I did review it, Judge, and we don't agree to it. I think what would be fair to say is that we now stipulate to it. I don't think it's fair to say that you're overruling your ruling. We're just saying we changed our mind and we stipulate to the admission of this report, so it's admitted.
And Judge, of course, that would not be accurate, because what happened in front of the jury was the defense tendered a piece of evidence, the state objected, and the court sustained that objection, meaning it did not go into evidence. So that's what the jury saw. They saw that I did something that the court didn't agree with and sustained the state's objection, and therefore I think it's incumbent upon the court to set that right specifically, and that's why I've used the language that I have in that proposed instruction, which says just that. I tendered a piece of evidence, the state objected, the court sustained, the court has revisited that, and will now allow it into evidence.
Well, I don't intend to do either what y'all say. Here's what we'll do. Last week during the testimony of Cobb County Police Officer Gallimore, the defense offered into evidence a copy of Officer Gallimore's police report. The court has reconsidered its ruling not allowing the exhibit into evidence. Officer Gallimore's written report is admitted into evidence as defendant's exhibit 3. I'll do that.
Thank you, Judge.
Any objection?
That's fine, Judge.
All right. Now, we can do that first thing. Anything else? The state or defense?
No, ma'am.
Judge.
Y'all have a good weekend.
You too.